Good morning and welcome to Sunday Square Off. I'm Bram Resnick. It's a new, unexpected battleground in Arizona's fight over disclosing dark money, anonymous donations that accounted for millions of dollars in election spending during the 2014 campaign. That battle resumes this week and could be a big deal in deciding who makes the rules on campaign spending. Secretary of State Michelle Reagan, our state's top elections officer, wants a relatively obscure body appointed by the governor to toss out campaign finance rules put in place by a commission created by voters. Joining us now, representatives of both sides, Eric Spencer, State Elections Director under Michelle Reagan, and Thomas Collins, Executive Director of the Citizens Clean Elections Commission. Welcome to Square Off.
Thanks, Bram.
Thank you.
Deep topic. A lot of issues here. Let's start top line. For the average voter, what is at stake in this debate? Eric Spencer.
Well, Bram, it's simple. Secretary of State Reagan is pushing back on a pretty obscure and long unaccountable agency known as the Clean Elections Commission that seems to be obsessed with flexing its regulatory muscle on political areas that it doesn't have any jurisdiction over. I think it will pretty much always continue to be obscure, but it shouldn't always be unaccountable. Everybody in government, from Secretary of State Reagan, who administers the law, to the Attorney General who enforces it, to the legislature that makes the law, is accountable, and so is every other state agency. And we don't think the Clean Elections Commission should continue to be exempt from that principle. So we're standing for government accountability and the fact that no one should be above the law.
Tom Collins, what's at stake?
Well, I think to understand where the commission is, I don't know that the commission is particularly obscure. What the Clean Elections Commission is a body created by the voters to administer the Clean Elections Act. And what voters did when they enacted the Clean Elections Act is they wanted to have ways of bringing people into the political process, and that was a way of pushing corruption out. And one of the ways you do that is by open, honest, and transparent enforcement of campaign finance laws. And the Clean Elections Commission has been doing this for years. It's recently become something of a battle between the commission, I guess, and the Secretary's office, although I think the battle, if you will, comes from the Secretary's office on the commission. And what that, I think, is about is two things. First, the Secretary of State's office has said that disclosure of all that negative spending, all that what we call dark money, is all controlled by federal tax law, that's the beginning and end of the story, and that for that reason there's nothing that the Secretary of State's office, as I understand it, feels it can do about that. However, they've additionally decided that they would like to stop the Clean Elections Commission from applying state law to ensure that those folks who are supposed to report are in fact reporting. So there's two different things going on here. One is the decision by the Secretary of State's office, as I understand it, that there shouldn't be disclosure because of their view of the law, and then given this, the commission has a different view, preventing the commission from enforcing that.
Okay, I want to talk about the disclosure issue first, and then get to just where you guys see the boundaries, because it's still unclear in my mind where the dividing line is between your two offices. But on the disclosure issue, Secretary of State Reagan, legislator said we got to do something about dark money. Now, as the Secretary of State says, we can't do anything. Is that how you see it?
No, and just to be clear, that what's going on right now between the Commission and Secretary of State is not about dark money, it's about a power grab. But on that subject, we're about to introduce a bill to the Senate probably early next week in conjunction with our sponsor, who's been a great leader on this, that will finally give us the tools to get at the worst of the worst actors who engage in anonymous spending but don't have any accountability. So we hope that when that bill passes, we'll have some tools for the first time. So we're working through what the proper process is. You draft a bill, you go through the legislative process, and it's the lawmakers at the Capitol that make election policy. That's the way the world works. The Commission, I guess sensing a gap in how that process works, is not authorized to go out and make its own policy. It goes to the legislature, and we'll be leading that fight in a couple days.
Now, one of the rules you want thrown out by this Government Regulatory Review Council, which we'll talk about in a minute, does involve disclosure, dark money disclosure, doesn't it?
It's correct, and I know this will come as a shock to your viewers. It's probably the most pro-friendly dark money regulation you can imagine.
A clean elections regulation.
What they passed last October is probably the most pro-dark money regulation one can imagine.
Tom Collins?
Well, look, there's two different things, again, going on here. The first is, what did the voters authorize? The voters authorized the Clean Elections Commission to get reports on campaign spending and to enforce penalties against those who don't disclose their donors when they're supposed to. That's something that was in the act that the voters passed. That's not subject to debate. In fact, people like to say that Citizens United was the dawn of dark money, but the reality is that when voters passed the Clean Elections Act, there were provisions of the act that presaged something like Clean Elections.
So you're saying the law saw this coming?
That's correct. The Clean Elections Act did see this coming.
Did the law see this coming?
Tom has all that I think no one else possesses. It is indeed the case that the Citizens United decision by the Supreme Court in January 2010 unleashed for the first time a new type of spending where corporations and nonprofits for the first time could spend their own treasury monies to conduct political speech. That was not envisioned by the voters 12 years before that. Dark money as a term didn't even exist when the Clean Elections Act was passed. So there's no way that voters could have foresaw where the law was going to go 16 years later.
That's not true. I mean, from the Clean Elections perspective, the Clean Elections Act, on its face, required reports of political spending. Even if that spending would have been illegal for a corporation, we had rules in place long before Citizens United that said a corporation that made expenditures was going to have to file reports that the Commission enforced. That's just a fact. That's the legal record. So I think that to suggest that our rule is, I think Eric said it was the most generous to dark money rule you could imagine. Well, I'm not sure that's probably true, given that no rule or no enforcement is a much different proposition. What this rule says is, look, we have a statute on the books that says that if the primary purpose is politics, you have to report. And all that our rule does is say, look, here's how we're going to determine primary purpose. If you meet this test, then you've got to file reports that are enforced by the Clean Elections Act. At the end of the day,
I'm going to hold you there because we're going to have to take a break and come back, discuss more of that, and also this body you'll be going to decide all these issues. When we come back, more of our conversation on rules for campaign cash. Then later, a heads up on the bills we'll be talking about at the legislature this week. A tax break for gun owners, and Governor Jan Brewer and other political insiders on the presidential campaign and Donald Trump. Stay with us.
It is an absolutely astonishing amount of money that's being spent.
Millions in anonymous donations buying nasty hit pieces in last year's Arizona Corporation Commission race. Is it free speech or a free kick? The Corporation Commission race last year was an eye-opener, an important regulatory agency most Arizonans have never heard of, where candidates were targeted by millions in dark money. It's now morphed into investigation of whether APS spent the money to stack the commission with favored candidates. That's become kind of the trophy issue for dark money. We're going to get back to that in just a moment. I want to start, though, with, this obscure body I mentioned that you are now bringing your case to, the Governor Regulatory Review Council. How do they have any standing in this?
They've always had standing, and the question is, why hasn't the Commission ever recognized the standing of the Regulatory Review Council? They're the experts on regulations. Every other agency in the state of Arizona has to go before that council and justify their regulation, both on the law and on the economic burden that it might propose. And for reasons that aren't entirely clear, the Clean Elections Commission has thumbed its nose at that process since its existence. The only thing it's submitting to is a 5-year review, and before the commission last week, the council last week, I think it was pretty astonishing that the Clean Elections Commission asserted that it is above the law and not subject to any kind of review.
So, to put it simply, who is the boss of the Clean Elections Commission?
Well, there's a couple of different things going on. First, the Governor's Regulatory Review Council doesn't have authority over the Commission to void its rules through this 5-year review process. If it did so, that would violate the Voter Protection Act. And as some of your viewers may know, the Clean Elections Act, as a thing passed by the voters, is protected by the Constitution. And you can't just do things to clean elections without a supermajority of the legislature that advances its purpose. So now, GERC's authority over the Commission itself...
GERC.
Right. That's what
Okay,
that's the
GERK.
jargon, GERK. So if you really want to be on the ends, you call it GERK.
Okay.
Is limited by statute, and it's in Article 3 of Chapter 6 of Title 41 that we're exempted from, and that shows that we are, in fact, not under GERK's oversight, and that's on purpose. So the boss of the Clean Elections Commission at the end of the day is the commissioners are appointed by the governor and the out-party leadership. They are removable by the governor and the legislature, but they are insulated from politics, and that's a really important point because the model of the Clean Elections Act, the model the voters wanted was a model that says we're going to have open, honest, objective evaluation on a multi-partisan, bipartisan basis that you can track to do enforcement. That's a totally different model that should be insulated from political comings and goings because it's supposed to be an institution voters can turn to rather than having just and merely only elected officials who are ultimately in the business of raising money be the people who supervise that. Now, we don't take anything away from the secretary, but...
Okay. GERK, this review council, it's also appointed by the governor. Might be a friendlier venue.
Some members are appointed by the governor. Other members are appointed by the speaker and the president. So it's a bipartisan group of business owners and folks from the community that are designed to serve as a check on government abuse. And the word that my friend Tom just used several times is telling, insulated. The Clean Elections Commission believes that it is insulated. It's insulated from the law. It's insulated from accountability. It's insulated from the voters. And they take a weird sense of pride about not playing by the same set of rules that everybody else plays by. We're all accountable, and we're just asking for the Regulatory Review Council to take a look at Clean Elections rules and see if they meet the requirements of state law.
Last word, Tom Collins.
Well, look, there's nothing that the Clean Elections Act does that in any way helps the Secretary of State. The Clean Elections Act is administered on an independent basis by commissioners of all parties, Republicans, Independents, and Democrats. They've done it fairly. They continue to do it fairly. It's transparent, and people can follow it, and that's what people want, and that's what they voted for.
All right. This should be heard this week by?
On Tuesday.
On Tuesday. Is it appealable? Anything they may decide appealable?
Well, the Commission's position
yes or no?
is that the Commission believes that they can't do this.
All right. See how that plays out. Eric Spencer, Tom Collins, thanks so much for joining us.
Thanks, Ron.
When we come back, the bills to watch this week at the legislature, guns, school vouchers, and more. Stay with us.